So what is the authority of the law? Authority of the law is like sovereignty or legitimacy, one of those concepts which are totally underspecified, and if you have three people talking about the authority of the law, there will be 4 points of view. I want to treat it, therefore, in terms of its compliance pool, authority as measured by compliance pool, the ability of the law to generate loyalty and compliance even to laws with which you are not happy, and respect. In other words, not just complying because the law is the law is the law, but because of some kind of, and not just a commitment to the rule of law, but a commitment to the ideas behind which the law, which you are complying with, stands for. So it's in that sense that I am talking about the authority of the law. Now, our tendency when we talk about European law is immediately to focus on the European Court of Justice. But it would be a mistake in this context. I will get to the... Fasten your seatbelt. But if we want to talk about compliance pool, the lawmakers have to come under scrutiny as well, and the process by which the law is made. So I listened to Pavel Telička earlier, and I was really impressed by the optimism and enthusiasm. But in my view, what he said is also part of the problem in terms of the process of lawmaking. Because his vision for the future, which I hope will be realized, is very much result-oriented. We need better regulation. We need new sectors of the economy. The European Union has to deliver on the promises that it makes and the expectations that citizens have. All this is correct. But that is taking us, our citizens, we, a little bit cheaply. Because we're not only interested in results. We do not belong to the generation of bread and circus. As long as there's employment and as long as there's good regulation and administration, then we don't worry about anything else. When we speak about democracy, we are also concerned with process. Otherwise, we would appoint king philosophers. They would do a better job. And we delude ourselves if we think that the process we have today in terms of making European law is, you know, we always talked about the democracy deficit, that we solve that because the European Parliament is a co-legislature with the Council, so there's no longer a democracy deficit. In my view, that is a dangerous delusion. And I don't like some of the populist parties any more than anybody I expect is sitting here. But it's too easy just to point a finger and say those awful populists, etc. If we don't recognize that there is something very deep in the way we make European law which is very problematic, how can we not ask ourselves the following question? How come that since 1979, when the European Parliament was not nearly as powerful as it is today. I'm saying 79, first direct elections to the European Parliament. And since then, progressively, with every treaty amendment up to Lisbon, the European Parliament got more power and more authority. How come in this period, in every election, less and less people went and voted in elections to the European Parliament? How can we not ask ourselves that question? And if we are serious and not just want to point fingers at the awful populists and those silly Eurosceptics who don't understand and we just have to explain to them better, we have to, and this is our job as academics and intellectuals, we have tenure, that's why we have tenure. We have to examine ourselves. And I can very briefly tell you why I think less and less people have gone and voted for the European Parliament. And they went and voted less and less, even in the period before the 2008 financial crisis, when the going was good and the union was delivering and the promises were fulfilled and it all looked bright and rosy. Also then, there was a continuous steady decline. It's because in our structure of European Union lawmaking, we do not respect sufficiently the two most primitive elements of what we call democracies in our member states. One is the principle of accountability. The British have a wonderful phrase for that. The ability, every 4 or 5 or 6 years, depending on the electoral cycle, to throw the scoundrels out. That through your vote, you decide who is going to govern you. I actually believe the Spitzenkandidaten exercise was a wonderful innovation. The beginning of something that has to be continued and made more profound. But the way we structure our governance, there is no moment in the civic life where a citizen says, if enough people vote the way I vote, I can tell who will govern me, by whom I will be governed. That cuts across all democratic systems we know, the German system, the French system, the British system. You get to decide in your vote by whom you will be governed. It doesn't exist to date sufficiently in the European Union. So when, I'm not Brecht, you know, the people have disappointed, let's change the people. I think the people are wise. Why should I get up and vote if in these elections I actually don't get to decide this one thing of who gets to govern? We need to think about that deeply. Instead of talking about the democracy deficit, let's talk about the political deficit. And the second precondition of primitive exists everywhere, except in our union of democracy, is, the politologists call it voter preference. If enough people vote in a certain way, it can shape the direction of policy. If enough people vote in a certain way, the policies adopted, redistributive and others, will be either center-right or center-left. It makes a difference who gets elected in our national. Not as huge a difference as the purists would like, but it makes a difference. There's not a single study that shows in a systematic way, not in an anecdotal way, that voter preferences in elections to the European Parliament shapes the policies adopted by the European Union. That's the principle of representation. So even though there might be a majority of Christian Democrats or a majority of Social Democrats and, you know, the family, as they say, the left family or the right family, it doesn't get translated into the direction that the union takes. And when these two conditions that are primitive, even if you have them, it's very far from being a perfect democracy, but if you don't have it, we delude ourselves if we think all is well. And a condition for the authority of the law is not just that it's better regulation and that it delivers the results, but that the process by which it is adopted gives it what we call democratic legitimacy. That the citizen says it was made by, and respecting the preferences expressed by myself, the citizens, and my others who voted. And in a deep sense, it's not just the tragedy of Brexit, as we heard, it's the pathology of Brexit. But in a deep sense, what I'm talking about feeds that pathology, feeds that inability. Republicanism, I mean, in the democratic theory sense, is that you do not belong to the patria, to the polity belongs to you, and the only way that you feel that you belong to, that the polity belongs to you, is through your vote and through your taxes. And in the European Union, we have neither. Our vote doesn't determine who governs us, it doesn't determine the shape of policies adopted by the Union, and we don't pay taxes to the Union. We pay taxes to the member states, which are then transferred. So if we think about the crisis of authority, we have to also be thinking about this process and not only result. So now the court, because the authority of the law is not only how it is made, but how it is administered, and how it is administered and enforced, the court plays an important role. And in this respect, we have a remarkable institution. I'm still used to calling it the European Court of Justice, not the Court of Justice of the European Union. I think we are brothers in that, are we not?
We are.
But we also make a mistake, because we should talk about the courts, and I don't just mean the Court of Justice and the General Court, but the courts of the member state. Because that's the secret of our system. That's the secret of our system. Primus inter pares. And that's historically what transformed European law in the European Union, is unlike the law in any other international organization. And it's not just because there's so much more of it. It's because the unintended genius, because for sure they didn't have this in mind when they established the preliminary reference procedure. From what we don't have the travaux préparatoires, but we have memoirs. They didn't have it in mind. But the genius of the system is that in most cases, the law of the European Union is spoken through the mouths of national judges. And the compliance pool of a national judge is higher than the compliance pool of an international tribunal. When the International Court of Justice makes a controversial decision, the reaction of the ministry in question is, we will study the decision. And 2 weeks later, it's already old news. When a national court in a country which respects the rule of law makes a decision which is uncomfortable to the government, and the minister calls the civil servant and says, what do we do with that? The civil servant looks at him with astonishment and says, what do you mean, what do we do? We either appeal or we comply, but there's no other option, is there? But for that to be successful, there has to be this very healthy relationship between our national judges, wearing their hats as European Union judges, and the European Court of Justice. And I think historically the court has done well in that. We have not had, there have been isolated cases, but we have not had a rebellion. But there is nothing that is so good that cannot be made better. And I want to, and with this I will end, I want to speak about 4 or 5 elements where I think we can enhance the authority of the European Court of Justice, not just in general in the eyes of the public, but in the eyes of its principal interlocutors, which are the member states. So the first element is how we appoint our judges. And there's a problem there. So you all know that just a few weeks ago, the Commission began infringement procedures against Poland. And at the heart of the infringement procedure against Poland was the new law under which, when Polish judges reach the age of retirement, the minister in question gets to decide which judge will get extended, would be prolonged, and which judge will have to go home. And the Commission rightly said that this violates the principle of the rule of law, the independence of the judiciary. Because after all, it's that minister whose laws, etc., might be a subject for judicial proceedings. And if judges know that that minister is responsible for the decision whether or not they can continue in office, I think everybody or most people in this room would agree that the Commission is rightly concerned that this is a serious violation of the principle of the rule of law. But as I did with democracy, let's look at our own practices. When an advocate general among the 6 privileged ones, when his term of office terminates, he has to be renewed, or she has to be renewed, right? Who decides whether they will be renewed? Their minister back at home. Mr. Lennartz, recently, presidents of the court have served for long periods of time, longer than the individual mandate of a judge. For our own good, I hope that you will serve a very long period of time.
Thank you. I'll do my best.
But it will depend on the goodwill of your minister. Because if he, for whatever reason, decides he doesn't like what Lennartz is doing, or he doesn't like what the European Court of Justice is doing, all he has to decide is to put forward a different candidate. It's the same violation of the rule of law against which infringement procedure are brought. Now, I want to extend this because I'm getting to my pet topic. How do we solve this? I mean, I believe that the political process should be responsible for appointment of judges. I don't believe in a purely professional, judges choosing judges. On 2 occasions, at least, I am aware of, it might have been more, proposals were put to the intergovernmental conferences amending the treaties to limit the term of office of judges of the European Court of Justice and the permanent advocates general. 9 years, 12 years, take your pick. The Italian Constitutional Court, the German Constitutional Court, Spanish Constitutional Court, etc. And of course, that guarantees independence from the political branch, because if you are not renewable, you don't depend on your minister. In my view, ominously, suspiciously, it was rejected on both occasions. The member states didn't want to accept that proposal. Why? We can only speculate, but I leave you to do the speculation. But there's a more important point than that. Although I do think that when you come up with your new package of proposed reforms, a central one should be judges are appointed to the court for 9 years or 12 years and then it's over. And it's not only to disconnect this dependence on ministers at home of who will be renewed and who will not be renewed. But because if I understand you correctly, and if not, I'm sure you will correct me, as you always do.
Of course.
The fact that they have this renewal procedure is part of the explanation why there are no separate or dissenting opinion in the court. Because because of the renewal, then there might be an expectation that the Polish judge will dissent on a judgment against Poland, and because if not... And now I will express my values. I am of the opinion that having the possibility of dissenting opinions to be used rarely would vastly increase something very important about the decisions of the European Court of Justice. 2 things. First of all, you decide by consensus. And when you decide by consensus, you are reduced to what all the judges in the chamber can agree on. And the result is a suboptimal decision sometimes, which there was a majority that would have gone in this direction, but we have to live with what we have. But also a very serious problem of the communicative dimension of the judgment. Because very often they agree on the result but don't agree on the reasoning, so you cut it down to 2 sentences, because on those 2 sentences they can all agree, yes, no. And I'm not going to do it, but to not spoil the party. But there's a long list of judgments where you just say, how is it possible dealing with such a fundamental issue, so complex, and it's reduced to 27 words in 2 recitals of the decision? That cannot be. Because the authority of the law, and now it's not just the compliance pool, I said also respect. The court is an important partner in the constitutional conversation of the European Union. And when, because of this exigency, the collegial nature, no dissenting opinion, deciding by consensus, etc., it reduces its effectiveness as an important voice in the constitutional discussion. I actually checked it. When I looked, the Financial Times is a reasonably serious newspaper. So I looked back at their reports of decisions of the European Court of Justice, and they always limited to the decision, what the court decided. There's never a reference, as you find in the United Kingdom or the United States or Germany, Because there we have courts who believe in the power of the word and that their decisions should be well explained. It's not enough to get it right. People have to believe that you're right through the explanation that you give. So when the newspapers report in those jurisdictions, there's serious attention to the reasoning. I don't blame them with the European Court of Justice, because sometimes even I have problems kind of wrapping my mind around, so what really was the explanation? And this goes to, you see how it's all connected. Not having a fixed term not only creates a dependence on the ministry, but also prevents dissenting opinion. Not having dissenting opinion, having to decide by consensus, reduces the quality of the decision and its communicative policy, and the ability of the court to explain important things that sometimes are more important than the actual decision that they take in terms of its outcome. We have a wonderful court. We have wonderful courts because the history facts speak. But as I said, there's nothing that is so good that cannot be made even better. Thank you very much, Chairman.
Thank you.